Hello, everyone. Welcome. So, we're just going to go to the Judiciary of Jamaica, their live stream, for some key moments from the case, all right, involving the King versus Jolyan Silvera. So, it's pretty much the sentencing, and I wanted to share just some key moments from the sentencing hearing. So if you're just coming over, please remember to hit the like button, the share button, and of course the subscription button. Let's see how best we can get this one going. All right, so right here, all right, Justice Sykes is saying, you know what, we're gonna start. So the starting point in the context of arriving at a sentence for Mr. Silvera was 25 years. All right, let's keep going.
And the culpability in this case, the offender is the principal in the first degree. It was his act that caused the death, and it was a deliberate and voluntary act.
All right, guys. So my understanding is that you perhaps missed that little first part. So we're gonna see if we can go back there to just where we kind of started. All right, so let's just see if we can get there. All right, so let's try right here. Welcome, guys. If you're just tuning in, please remember to hit the like button, the share button, and of course the subscription button. So we're just looking at some key moments from the sentencing hearing for Mr. Jolyan Silvera. Welcome.
Is about 25 years. And so, in my view, a starting point should really be, in this case, about 25 years. So that is where I anchor the starting point. That is in respect of count 2. The harm was significant, and the culpability in this case, the offender is the principal in the first degree. It was his act that caused the death, and it was a deliberate and voluntary act. And that is also in the context of the movement to raise the levels of sentencing applicable to murder. So in my view, there should be a clear distinction between manslaughter and murder and wounding with intent. Yes, a very serious wounding with intent will maybe overlap with lower culpability manslaughter, A manslaughter sentence at the higher end may overlap a little bit with the lower end for murder, but nonetheless, the distinction between the offenses should be maintained, and offenses that involve a homicide should always be regarded as a class apart from any other sentence, if for no other reason that the victim's, the deceased's right to life has been violated in a fundamental way, and it is an irreversible state of affairs. Then now, having established this anchor point, the starting point that reflects the gravity of the offense itself, reflecting its seriousness, the degree of harm, the level of culpability of the offender, then we go on to the next stage now of whether there should be upward or downward adjustment. And just to make the point that when you're dealing with upward adjustment as a result of aggravating factors, downward adjustment, mitigating factors.
So right here, justice is about to go up and down in the context of years for the sentencing. So here, justice is sharing that aggravating factors, well, and I'm not sure if he did just now, but aggravating factors will add more time to the sentence, and his starting point was 25. So you can listen out for that. It's going to move it from 25 to 31. And then mitigating factors, they're going to reduce the time. So it's going to go from 31 and it's going to go back down. All right, so let's just go back to Justice Sykes.
Now, it doesn't mean that in every case there's going to be an aggravating factor or mitigating. So the judge is not to manufacture aggravating and mitigating factors. If none exist outside the commission of the offense, then that is it. So the judge can't go squeezing and torturing the evidence to find an aggravating or mitigating factor. Now, in this case, we have had submissions from counsel on both sides, and I thank them for their assistance. I mean, I really thank them, not saying it because it's something to be said. So, we've also had the character witnesses as well, coming in from the defense. The Crown is emphasizing these factors that it says are aggravating factors. That is, Mr. Silvera would have known what happened. The Crown is also suggesting that Mr. Silvera has been before the court since 2024, early 2024, January 2024. So what he's saying is not really anything new, because he would have known about the argument in the bedroom. He would have known that he was the one who actually shot her. He would have known that she was either dead or dying when he left, and there is no evidence that he sought any assistance from anyone. You know, there's an accident at my home, please come. It was the discovery of the body by the children and the call based upon the narrative that brought him back to the house. So the Crown's position seems to be that he should not receive any discount because of the guilty plea, or very little because of the timing. And then, so we'll see what we make of that at the appropriate time. But that's the argument as I understand it. There's also a statute that regulates or has some assistance, provides some assistance here. This is the Criminal Justice Administration Amendment Act of 2015. And Part 1A speaks of reduction of sentence on guilty pleas. And in particular, it speaks to first relevant date, which means the first date at which a defendant who is represented by an attorney at law or who elects not to be represented by an attorney at law is brought before the court after the judge or magistrate, and this is the critical part now, is satisfied that the prosecution has made adequate, not complete, adequate disclosure to the defendant of the case against him in respect of the charge for which he is before the court. So the whole idea there of the legislation is that it is not the first day that you appear before the court, but what information did you have from the prosecution that would enable you to make an informed decision. And so the prosecution's argument is that disclosure was made in early January. Post-mortem examination was served as well. So they are saying, separate and apart from what he knew, he also had information that outlined that it was his firearm that caused death of this person. And so the prosecution is suggesting then that the delay in entering a plea was, my words now, not theirs, playing the odds. Let us go along, see what happens, and then I will make a decision. So the prosecution is suggesting that this was a tactical move on the part of the defendant. And so the prosecution is suggesting then that this guilty plea, helpful as it is, should not, Mr. Silvera should not benefit from the generosity of the statute to the fullest extent. Well, we'll see what to make of that at the appropriate time, but the cases do indicate that a guilty plea is of value. What is the value? One, it minimizes, well, it removes the trauma of witnesses having to testify. It frees up resources so that it can be dedicated to other cases, and the person has accepted responsibility. So if for no other reason, then it should be recognized as a mitigating factor. So we have to weigh all of that. Another So in my view, in looking at this matter, what are the aggravating features? This is a killing in the context of a domestic setting. Mrs. Silvera was in her house. It is a place that she was entitled to feel that she could be safe, or at least not shot and killed. And the children have been deprived of a mother. So those are aggravating features. Another, to me, aggravating feature, because the narrative of the Crown didn't indicate whether death was instantaneous or she was alive for some time. It wasn't clear on the narrative. But it means that if she didn't die immediately, then she would have been left there to succumb to her injuries. If she died immediately, based upon the narrative, these two youngsters, very young gentlemen, would have, as children normally do, you get up and you go into your parents' room. That's what children normally do, to stumble upon this there and leaving the children to make that discovery with no support. No, there's no evidence that any other adult was at the property. And so they did what children do, you call the other parent. And then, when he came, pretending that he was just as surprised as anyone else about the death of Mrs. Silvera. All of these, to me, are aggravating circumstances. In addition to that, let me get back to the narrative here outlined by the Crown in respect of the ballistic evidence. Because it was the ballistic evidence that anchored Mr. Silvera to the crime. There is no report that the firearm was missing. No report that it was mislaid. No report that it was stolen. And his initial response to the police granted, I will accept that the police officer had a responsibility. You can't be there being taken in by all of this. You go and you see a body. As a police officer, you're not a pathologist, but at the very least, you should be saying, don't touch the body. Call the crime scene persons. Let us see what happened here. So I wouldn't expect the police officer to be going over there pretending as if he's a forensic pathologist. But the police officer, being, I suppose, misguided sympathy here, was being taken in by the act of Mr. Silvera, to the extent that the police officer now, rather than doing his duty, he is now treating this as if it's just an unexpected death that may have been by a heart attack or some such thing. And during that, Mr. Silvera would have known that he was the person who was responsible for her death. The post-mortem says she got 3 gunshot injuries. And he was even telling the police officer that as far as he knew, she had no known medical condition that would cause her to be in the state that she was found, which is all the more reason why the police officer should have been far more alert than he was. And I had conduct of the matter when it first came for trial in February. And I will never say that a defendant cannot exercise his right to have the prosecution case tested. I have no difficulty with that. I have no difficulty with seeking your own forensic services. I have no difficulty with that either. But the fact of the matter is that when the matter came up, the defendant wanted his own forensic person, and that's fine. But it's in a context where you knew what happened. You knew. And when the forensic legal professional privilege, I won't get into that, but the fact of the matter is that it seems to me that the effort here was directed to see if there was some room to maneuver regarding the ballistic evidence, because that was the anchor of the prosecution case. And then, after you had that opportunity, then the guilty plea came. So in other words, from December 2023, right up to February 2026, it was a state of denial, non-acceptance of responsibility. So that is going to inform how I view the plea of guilty. Context matters. So yes, you have accepted responsibility, but it seems to me that the acceptance came because of the quality of the work done by the Jamaican ballistic experts. And what is the expert saying? The expert is saying two things. One level of marking, you get the firearm category. Two, next level of marking, I keep using the word marking. Matching, you get the specific firearm. And he's suggesting that what he saw in the barrel was not the result of the natural processes of corrosion and so on, but a deliberate effort. And he's also suggesting that the impact would be that bullets fired after the interference may be different in its markings and so on to facilitate identification, different from markings before the gun was fired. In other words, we can't be sure. So that's how I come to it. And September 29, 2023 is a significant date. It shows the value of proper processes. The value of proper processes is that the FLA did what it was supposed to do. You come to renew the license, give me your gun, let me look at it. Do I see any signs of tampering, corrosion, anything altering? Because one part of their responsibility is to keep signatures of all firearms of private citizens so that the very thing that has happened here, the police investigation can proceed and you identify the firearm. But the problem was, and here's the problem. The problem was the pathologist. She was the fly in the ointment because when the body was removed, death from some cause other than violence. And it was the pathologist came along and said, what? No. We're going to deal with this differently now. It was her alertness. And based upon all the evidence, but for her alertness and professionalism, we wouldn't be here now. So that is part of the context for me. So those are the aggravating factors. Why are those latter things aggravating to me? Because it suggested an effort now to disguise, to cover up, to escape. And the science put naught to that. And when you had your opportunity to have your expert examine, no wriggle room. The expert, the Jamaican expert, couldn't be discredited. So we are here. Now, on the positive side now, the mitigating factors, which must be taken into account.
All right, welcome. If you're just tuning in, welcome one, welcome all. So Justice Sykes, has just gone through the aggravating factors. And again, the aggravating factors, they added time to the starting point of 25 years. So some of the factors that, the judge shared was the fact that this crime happened in a domestic setting. And so, Melissa, the victim, should feel a sense of safety in their home. So, that was an aggravating factor. The children, so the impact on the children, the fact that the children discovered their mom's body without support, right? There is also the consideration that, it could be a situation where she was left suffering without, any help because Mr. Silvera left. The tampering with evidence, and so there was this deliberate attempt to corrode the firearm barrel to prevent ballistic matching. And so, that was an aggravating factor in that context for the judge. The attempt to cover up. So he felt that there was a strategic move at covering up this crime. And so there was this move prior to Mr. Silvera pleading guilty. All right. And so he was pretending to be surprised by the death of his wife. So these are factors that, the judge will use to add time. All right. So let's just continue. I believe he's going to go to the mitigating factors. And the mitigating factors, these factors will reduce. So these are circumstances or elements that will take away from time. So you will go with the aggravating factors and it'll go all the way to 31 years. And then the mitigating factors will lower that 31 years. So let's go back to the judge.
Counts. No previous conviction. Clearly. Person of good characters, King's Counsel said, you were an elected representative. Some persons may believe that that is not necessarily a mark of distinction, but nonetheless, the electors of St. Mary found that you are a worthy person to represent, and that must be taken into account. There's no doubt about that. The evidence of your character witnesses, because as I've always said, if you have lived a hitherto a previously good life, and when you get into difficulty, your good character cannot assist you, then what is the point? So yes, it has to be taken into account. The impact on the children, that is to say, the surviving parent will be away from the children for some time. That's a mitigating factor. The social inquiry report speaks positively about your work, your contribution, the relationship with your children, and by all accounts, you're an effective father. And by effective, I don't mean just like functioning like an ATM now, but presence, active involvement, all of those have to be taken into account. The victim impact statements, Council made reference to them, I looked at them. The jurisprudence suggests that they are not to be used as an aggravating factor, but to be taken into account in determining the initial categorization of the offense, but it's not supposed to have a decisive or impact to say the sentence goes up by a significant number of years, but it is factored into the process because there's always going to be a negative impact on those who are left behind. And it is not to be used to determine the level of sentencing ultimately. So it's taken into account. And as I said, and this is the difficulty in sentencing, there's no science that says aggravating factors mean you go up by 6 years, 7 years, or this particular factor is tied to a particular mathematical relationship. There's nothing like that. But nonetheless, it's a principle that we have to apply. And in my view, since I said the anchor point was 25 years, when you take into account the uplift as a result of the aggravating factors, I would say overall it goes up by roughly 6 years. The mitigating factors, it will come down by say, to make it what, 31? From 25, the mitigating factors, you come down by say 4 years, that would leave it at 27. Now, having done that,
All right, so welcome if you're just tuning in. Please remember to hit the like button, the share button, and of course the subscription button. So the starting point, a key moment of the sentencing hearing was 25 years in the context of the aggravating factors. All right, so which included the domestic setting, so the lack of safety, because Mrs. Silvera should have had a sense of safety in their home, tampering with evidence, the cover up, the impact on the children. Those were some aggravating factors that added 6 years, 31 years. In the context of the mitigating factors, some included the good character of Mr. Silvera, so there were no previous convictions. The social inquiry report was good, and I think he's going to talk about the guilty plea, or perhaps he did, perhaps I missed it. This is like my second time going around, so I have some understanding of what was shared. That's going to be taken into consideration as well. The fact that he spared, for example, his children from testifying, albeit the fact that it came late and it was a strategic attempt. All right, and so another mitigating factor that the judge took into consideration was the fact that Mr. Silvera is the only surviving parent, and being away, I'm noting that the children have been deprived of a mother and will now also be separated from their father, who is the surviving parent, for a significant period. So this separation was cited as a mitigating factor in the sentencing process. So again, that will take away years. So far, he also spoke of the social inquiry report. Again, that spoke positively about Mr. Silvera and the fact that he was described as an effective father. And the judge went to really clarify what he meant by an effective father, that he was active based on his presence and contributions rather than just functioning as an ATM for financial support. So the judge also characterized this aspect as a mitigating factor. And so, with that said, so far, with 31 years, with the 6 years added for aggravating factors, the judge now at this point um reduce the sentencing by 4 years for mitigating factors. So he will continue, and then we'll see how we got to that 20 years, 10 months. So let's keep going. Welcome again if you're just tuning in.
We go to the statute now, where you look at things like the guilty plea. I note the words of the prosecution, and I am not seeking to undermine the defendant's right to have counsel. And of course, clients are like patients of doctors. They can give the advice, but they may or may not follow it. And so counsel has to work with the client that he has. I am not saying anything one way or the other, but it's just the nature of the job. A lawyer can only advise, but the clients have to decide. And sometimes it takes a bit longer for some persons to get to that point than others. And counsel may very well point out all the rational arguments as to why they should do things at a particular time, but some clients just don't act in the way that they ought to. There's nothing the lawyer can do about that, but you still have to work with the material that you have. So counsel referred to the Criminal Justice Administration Act of 2015, where it says, pursuant to subsection 1, the court may reduce the sentence that it would otherwise have imposed on the defendant in the following manner, where the defendant indicates to the court on the first relevant day that he wishes to plead guilty to the offense, the sentence may be reduced by up to 50%. Well, I don't think we're at the first relevant date. Let's go to paragraph B, where the defendant indicates to the court after the first relevant date, but before the trial commences, that he wishes to plead guilty, the sentence may be reduced by up to 35%. I think could say that he fits in there somewhere, where the defendant pleads guilty to the offense after the commencement of the trial, clearly not there. So where we are is paragraph B, after the first relevant date and before the trial commences. It says may be reduced by up to 35%. Now, what this provision is designed to do is to incentivize guilty pleas. But I suspect, and this is something now for law reform and the legislation, when you have the pairing of the offenses here of manslaughter, which the judge has more this discretion there, with using a firearm, which is a mandatory minimum, then you wonder how does a defendant get the benefit of this? It's because if you plead guilty at the earth date, it's a minimum of 20 years, and if you plead 12 months later, it's still a minimum of 20 years. So that has to be taken into account as well, because there's really no benefit, really, for entering an early plea where you have a mandatory minimum of 20 years. So maybe the legislation should say something like, if he indicates on the first relevant date that he wishes to plead guilty, then notwithstanding the existence of a mandatory minimum, then the court can go below the minimum, because what you want to do is to incentivize persons to enter pleas rather than make it virtually pointless to enter a plea, since you're going to end up at more or less the same place, whether you go through a trial or you enter a plea. So I can understand those considerations. But nonetheless, he entered a plea, and it is of value. And I've indicated what that value is. So that should result in a further reduction. I don't think it's going to be as high as 35 percent because of the context in which the guilty plea occurred, but nonetheless, it is a value. So, and in this particular case, had it gone to trial, quite likely the Crown would have had to call the children to give the evidence, and so that spared them the difficulty there, which is something that inures to his benefit. So, again, there is no precise mathematics here, but in the context of this case, I think that that is worth a further reduction of 4 years. That takes us down to 23. Now we're going to get into the percentage, but we're certainly not 35%. So that takes us now down to 23.
All right, so here again, another big mitigating factor. Well, even though there was context provided for the judge here, was the discount for the guilty plea. And so the Chief Justice noted that while it was entered late, it still provided value by sparing the children and other witnesses from testifying. And so initially the judge considered I guess the judge considered this reduction as a 4 year reduction, all right. And again, because of the context in which it came, the judge is saying, no, we're not going to go to the 35%, and he's not into any mathematical formula. So you went from 27, so with that 4 year reduction, to 23 years. All right. In the context of the firearm count, the judge explained that because there is a mandatory minimum for that count, which is using the firearm, he was restricted by that 20-year mandatory minimum sentence, right? So the guilty plea did not allow for a reduction below the statutory minimum. So when it comes on to the count using a firearm, then that discount, what the judge is saying, is not applicable because parliament legislators, they have decided that there is going to be a mandatory minimum of 20 years for these kind of offenses. All right, so now we're at 23 years in the context of this sentencing so far. And obviously they're going to take away the time that Mr. Silvera has spent in prison so far. So let's just go back to this update. If you're just tuning in, welcome. Please remember to hit the like button, the share button, the subscription button, and also leave your comments in the chat.
This is in respect of count 2. Other factor is a question of remorse. It's one of those intangibles where is the guilty plea a reflection of remorse or is it a tactical consideration? Well, I have indicated my position on that, and it seems to have been a tactical consideration rather than remorse. Though I acknowledge that he said in the social inquiry report that he's remorseful on all of those things. But having regard to the broader context, I think it was more strategic than remorse. But nonetheless, it's a guilty plea. Nonetheless, he has been in custody for 2 years plus, so that's 2 years from 23. 2 years and 16 days. Okay, let's call it um, 20 is what, 25, 26 months. 26, let's call it 26 months, 2 years down from 23, and makes it what, 21, and then you take out the 2 months, so that's 20 and 10 months. And I'm just checking to see if there's anything else that I need to bear in mind in terms of mitigating factors and their impact.
All right, so while the judge there was considering other factors, so a big factor here was regarding the total time served so far. And so Mr. Silvera here spent, I guess, about 26 months in custody prior to the sentencing. And so the sentence was reduced. All right, so this time was deducted from the calculated sentence of 23 years, bringing the final term down to 20 years and 10 months. So that's how the judge got to the 20 years and 10 months. Let's just go back to Chief Justice here.
And that seems to be it. I think that is it.
So right now I am just kind of hearing what I heard, and I'm wondering if that was Mr. Champagne when the judge was like asking, pretty much going over to see if he has captured all the mitigating factors. I heard age, age being said a couple of times there. So perhaps that was coming from, Mr. Champagne there. But let's keep going.
Right. So, in terms of count two, we are at 20 years, 10 months, and that's the time for count two. In respect of count one, well, I'm just a trial judge. I am not at liberty to ignore the words of the parliamentarians, and they have indicated that there is a minimum and a maximum, and they have indicated that the minimum is 20 years, maximum is 25. So again, a guilty plea is of inherent value, whether it shows remorse or not. At least that's my view. And so I can't go below what Parliament has said. I know Mr. Champagne has referred me to the decision from the Privy Council, but they are the Privy Council. So I think that it would be improper of me to do that, not because counsel is inherently wrong, but I think it is something that deserves full argument, at all the circumstances surrounding the legislation and so on, and all the relevant case law has been examined. It's very difficult to do that in the context of sentencing, and unless it's a clear authority from our Court of Appeal or the Privy Council to that effect. So, in respect of count one, sir, sentence is 20 years at a minimum. So, the other principle of sentencing is that sentences arising out of offenses arising out of the same factual circumstances are to run concurrently unless there is some good reason not to do so. There is no good reason not to do so in this case. So both offenses, sentences on both offenses, count one and count two, are to run concurrently. So it's 20 years on count one, 20 years, 10 months on count two. And so we are now happily at the end of this process. So let me again thank counsel for the Crown and counsel for the defense for the work that they have done, and again to recognize the significant work done by my judicial counsel, who at times I gave him things to do at very short notice. I know that he was.
All right, so the sentences for counts one and two, so 20 years as well as 20 years and 10 months, according to the Chief Justice. He ordered that the sentences for both offenses, so using a firearm to commit a felony count one and manslaughter count two, are to run concurrently. So this means the sentences are served at the same time rather than consecutively, so one after the other, resulting in a total time to be spent of 20 years and 10 months. All right. So let's just continue. Like it ended, but apparently Justice forgot about parole. So we're going to see him coming back. So let's just go back to Chief Justice here.
Was up late at night doing the research, so I thank him again. So he has enabled me to be here this morning to do this. And just again, a gentle reminder to the media, please do your reports in a manner that the persons, witnesses, or otherwise can be identified. Okay? So that's it then. So let's adjourn.
Dan, please.
Yes? Should be stated. Oh. Okay, let's all sit, have a seat. Yes.
In relation to section 101
101 of the
Firearms Act,
new act. Yes.
subsection 8, my lord,
101.
and paragraph B, my lord.
101 section
8, my lord, paragraph B.
Thank you.
Okay. So I'm being reminded here that section 101 of the Firearms Prohibition, Restriction and Regulation Act says, among other things, 101 subsection 8 says, unless otherwise specifically provided in this act, the penalty provided for an offense against this act is life imprisonment, notwithstanding anything in the act, the court shall specify a term of not less than 15 years that the offender shall serve before being eligible for parole. Well, that does not apply since the sentence for 14.2 is not life. And it says the alternative now is where there's a prescribed minimum. Notwithstanding anything in the Parole Act, the court shall specify a term of not less than 10 years that the offender shall serve before being eligible for parole. So I need to specify a term. Oh, well, okay. So anything on this, you have to give counsel a chance to be heard here, though.
Well, my lord, given the context in which, in terms of the plea, I would invite the court to invoke the minimum, my lord.
Very well.
All right, so they're just talking there, and they decided to just go offline for that part. In the context of muting, I suspect microphones, or I don't know if it was just a technical error there at this point. But the judge now is pretty much consulting both sides regarding eligibility for parole. So we heard from Mr. Champagne there asking for the minimum. Not sure what the prosecution stance is in this context because we're not getting audio at this point. But, justice will come back and let us know what his decision, is going to be in the context of this parole.
Subsection 2 of the legislation prescribes a minimum period of 20 years, and section 101, subsection 8 indicates that notwithstanding the Parole Act, the court shall specify a term of not less than 10 years that the offender shall serve before becoming eligible for parole. Now, clearly, I think in principle, the minimum, it sets a floor that you can't go below 10 years. So it now means that you have to go somewhere between 10 and the 20 years. The further context is this. The purpose of parole is to encourage good behavior. That's really it. So persons who behave well and are an asset and a credit to the institution while they are there should be able to use that as a basis for earlier release than if they were recalcitrants there. So it is really an incentive for the rehabilitation process. Now, it seems to me in principle, the difference between the stated sentence and the parole eligibility period should be sufficiently wide to incentivize good behavior, because if I were to say 17 years, and really, what's the point? So I think that having regard to the fact that this felony resulted in a death, it should be higher than the 10 years because offenses other than death are at 10 years. So I don't think both of them in principle should be the same. But the question is how far up? So again, no science here. So it must be sufficiently wide to be meaningful. And so that is what I'm going to do and suggest that the minimum period before becoming eligible for parole in respect of count one should be 13 years.
I didn't hear Lordship.
13.
30, thank you.
13, 1, 3. Yes. So, I think I've covered everything now, I hope. Yes. Thank you all very much. That's it. Adjournment, please.
All right, so in the context of parole eligibility, all right, Chief Justice set this period for 13 years. So the judge noted that the difference between the stated sentence and parole eligibility should be wide enough to incentivize good behavior and rehabilitation, especially since this felony resulted in a death. All right. And so he was sharing that I cannot give the minimum of 10 years because we would have had other contexts or situations which perhaps um, do not include debt, and so we have to go above the minimum, and he decided that 13 years, that's going to be it. So this is pretty much
And
the
please.
end here. All right, so thank you guys so much for coming over. Please remember to hit the like button, the share button, the subscription button. Leave your comments in the chat in the context of, just your views on this sentencing hearing, or just the time that was given of 20 years and 10 months and 13 years before being eligible for parole. All right, thank you again for tuning in. All the best, and we'll see you in the next one. Take care.
This honorable court now stands adjourned. God save the king.